Alright, hello and welcome to my video blog. And in this video blog, I'm talking about a subject that I'm really excited about for two reasons. I'm going to talk about support animals in the courtroom. And the reason I'm excited about it is twofold. First, I'm excited because I like the idea of having support animals in the courtroom. I think it's a really sensible thing to do. But the other reason I'm excited about it is you may notice if you follow this blog, I try to give kudos to courts from time to time, and I have a couple of recent blogs. I've talked about really good decisions from the courts. I like the way the courts are approaching support animals in the courtroom, and I want to bring to you some cases that really show that courts are getting behind the idea of coming to sensible solutions, even if there's no clear legislative provision to do so. And that's really what I want to talk about today. I'm going to show you three ways in which the courts have allowed support animals in the courtroom. I'm not convinced that any of them are perfect, but what makes me really happy is they're considering this particular problem and addressing it in a sensible way. So that's what I'm here to talk about: support animals, which are generally support dogs, therapy dogs brought into the courtroom. Let's dig right into it. So this is one of those situations in which practice is going on before the law. And what I mean about that is dogs like Meryl here are now testifying or helping. Sorry, they're not testifying. They're sitting with witnesses as they testify in London, Ontario. There are also support dogs being used in Alberta and BC. We've seen media reports of this happening and a few cases discussing the way in which this takes place, even though there has been no real coherent policy or legislative guidance saying that support dogs should be used. In fact, I would argue that the law is against using support dogs, and I'll show you what I mean by that. So just as an aside, the reason that I'm looking into this is I write a book called Witnesses. I've been doing it for 20 years, and one of the key parts of it are about support provisions. So I have been following this issue of support animals for years. I started writing about it 3-4 years ago, just indicating, well, maybe it's going to happen. So I was pretty excited when I did an update. I'm working on a second edition that will expand the book into a range of evidence topics, and I was excited to see that the law has actually progressed in this area. And that's, a good thing to know. There are actually courts considering support animals. And here's the problem. Support persons were never allowed in the courtroom before. A witness was expected to sit up there on the witness stand and endure cross-examination all by themselves until this section of the code was enacted, which allows anybody in a proceedings against an accused in respect of a witness to allow a support person of the witness's choice to be presented to be present and close to the witness. Okay? If it's necessary to allow the witness to give a full and candid account. And let's just say the courts have been very generous in using this provision. They recognize that when you're dealing with, this used to be only for young persons, it's now for any witness. But I mean, when it was used for a young person, it was just like pretty automatic. Sometimes the court would scrutinize who the support person was, so they generally wouldn't allow somebody who was going to be a witness for understandable reasons. A little bit of scrutiny about who it was, but by and large, you need a support person. You need someone there to hold your hand. That person is not allowed to communicate with you, but they are there for you. Good idea. Let's just use it. What's the problem? Support person, a dog, I don't need to explain it to you, is not a person. So technically speaking, the dog doesn't fit. And the courts have every right, in my opinion, to stop the dog at the door so long as you're relying on this particular provision. So I want to talk about how the courts have dealt with it because, as I said, dogs are in the courtroom. It's happening. And my guess is it's happening in one of two ways, because I've seen some cases in the early days, and in the last version of my witnesses book, what I said was it seemed that just all parties were consenting to the procedure, and the judge was essentially allowing it to happen because nobody was arguing about it, and that's the way we do things sometimes, where we admit on consent. But since then, we've now had 3 cases where I don't think it's been contested, but the judge wanted to explore the way in which it was done. And what's interesting about it is the judges found 3 different ways to allow the dog to come into the courtroom. So the first of these is a British Columbia provincial court decision where essentially the judge, as far as I can tell, did what judges do sometimes, which is he got clever. And really, it is a clever decision. The judge says effectively, well, I'm not stretching the definition of person to include dog, but the dog handler is the support person. And this is in accordance with the spirit and intent of the testimonial accommodation. So, I mean, as a strict legal interpretive device, I can't say I'm thrilled with the decision, but in terms of solving a problem in a creative way that doesn't really affect anybody, I love it. I think that's exactly what it's designed to do. The judge just says, look, the dog is the support person. That's the way I'm going to rule on it, and that's the end of that. And the judge obviously wanted to let it happen. You know, what can I tell you? It's an interesting way of dealing with the problem. But it wasn't one that met the approval of Judge Band in an Ontario Court of Justice, who, you know, I think felt the legislation should be applied the way it was actually stated. And I can't say the judge is wrong in that. The judge essentially says, look, the handler is an appendage. There's no reason to believe that the handler is actually the support person. So you're essentially trying to skirt the legislation and allow somebody in for the wrong reasons. Obviously, the dog is not a person, so the judge wanted to find something else. So the judge went out and said, well, I'm going to apply the Canadian Victims' Bill of Rights Act, a new law that was put in by the Conservative government in the waning years of its governance. And that law says this: every victim has the right to request testimonial aids when appearing as a witness in proceedings relating to the offense. Again, fairly clever. And again, I'm pleased that the judge found a way to allow this to happen, which I think is the right thing to do. It's essentially what I'm saying is it's the right conclusion to actually reach. But if you're kind of a stickler for the law, I'm not wild about this approach either. The Canadian Bill of Rights Act, Canadian Victims' Bill of Rights, is very clearly not supposed to have substantive power. And the basic idea is you have to exercise those rights through the mechanisms provided by law. So this doesn't really get around the problem. Section 486.1 sub 2 is about support person. So I don't see how the judge can say, well, you have the right to request a testimonial aid that is not existent under the mechanisms provided by law. So again, the judge didn't consider this or didn't even address Section 19, and it's a very short decision where the judge grants the dog to come in. And I'm like, great, let's get the dog in there. But again, the law is a little shaky. And I think probably the best is Judge Roper's, the judge's decision in The Queen and Roper, where it wasn't a service animal, it was actually a pet lap dog, but the judge let it happen anyway. Said it's within the spirit of Section 486.1, but did so by exercising the inherent jurisdiction of a Superior Court judge. I actually think that's very sound. I think judges have the jurisdiction to allow this to come in. They have quite a bit of flexibility with respect to how a witness testifies, but the problem is that this will not help in cases where, they're tried in the provincial court, where judges don't have the inherent jurisdiction to control their own process in quite the same way. So it's not a perfect fix to the problem. And frankly, I just think it would be better for all concerned if Parliament just fixed this problem and recognized that there is a lot to be said about having therapy dogs in. And here's a quick summary of what I've said in my book over the last couple of years. So first and foremost, I cite a wonderful article documenting the American experience. And what this essentially sets out is a lot of the scientific studies that show the use of dogs, and in fact show that dogs are better than people as support persons. And here's why. In fact, this is, any students in law school today, most law schools across the country have dog therapy. Dogs come to law school. And the reason is because these dogs are trained to respond in a way that's in many ways better than humans. Dogs are better. Yes, dogs are better. The studies show that dogs have a sixth sense, an ability to sense the distress felt by the person and see how it changes. And these dogs have been trained to sense that emotion and help alleviate tension. And that's really important. So they're able to respond. And the fact is, anybody with kids knows, and let me just stress, this is not going to work for everybody. Some people have allergies, some people do not respond to dogs and would not want a therapy dog. They would prefer a support person, and of course that has to be available. But kids react to dogs in particular ways, and those dogs and the ability to pat the dog and feel the dog is something that can really help alleviate tension in critical moments of stress. So frankly, there's just really no good reason not to do this. Some people have raised the possibility that, in a jury case, jurors might feel sympathetic or too sympathetic to the witness, but even that's, can be rebutted. Dellinger wrote about this and said, dogs are less prejudicial than people. If you allow a support person, that person's sympathy for the witness is going to be much, much clearer. It's going to be much more visible. Whereas a dog might be, as you can see from this picture here, down in the box and able to put its head on the witness's lap. You're not even going to see it. The dog doesn't understand anything. It's neutral, effectively, with respect to the case. So there's really, to my mind, not a lot of strong arguments short of, individual ones, like the witness is allergic, or somebody, the judge is allergic or something like that, for not allowing dogs to play this role. So I guess I'd conclude by saying, you know what? Parliament, I know you're busy. Well, sort of busy, not doing the code reform that I'd like, but that's for another edition. Change it. Just change section 486.1 or study the issue at least if you're not convinced. Look at the studies. Let's see if it's worthwhile. The fact is, programs in parts of Alberta, British Columbia, and Ontario are all doing it already. It should be more. This is an easy, useful way to help child witnesses testify. Parliament, make it your mission. Let's get on it. Anyway, that's all I have to say about support dogs. Very excited, as you can tell, to talk about it. Have a great day.